We need to turn to our case law developments here in our presentations. We're going to have a case law update with the estimable Joseph Fortunato, Steve Bashaw, and Erica Minchella, followed by a discussion on the future of the profession by our own founder and chair, John O'Brien. Joseph Fortunato is one of the more esteemed colleagues that I can count. He's an intelligent and very knowledgeable real estate lawyer, former president, I might mention, of the Illinois Real Estate Lawyers Association, practicing now with the firm of Momkus, McCluskey, and Roberts as a result of the recent merger. He's an author. His book, Getting Started as a Real Estate Attorney, has been published by the American Bar Association Solo Small Firm and General Practice Division. You can go on the web and you can find this. It's only $900. No, it's not $900. It's less, right?
It's still too much.
It's still too much. Okay. He's also.
I didn't price it.
He's also counsel for the Main Street Organization of Realtors. He's one of the primary drafters of the multi-board contract. So anything in that multi-board 6.1 that you like, I drafted. If you don't, no, everything is basically his work, and it's a really wonderful work of art there. We're happy to see that contract gaining greater traction in various areas. And sooner or later, we're going to penetrate west of Rockford and south of I-80.
Excuse me, Ralph. Excuse me. If anybody has provisions of the 6.1 contract that they want to change, let us know. We'll always entertain proposals to change. We may not do it, but we'll always listen. So if you have some pet peeves or you have some ideas to improve it, please let Ralph know. Bombard his inbox, please, and then I'll look at them too.
We'll pass them on. But I thought we decided last time that it was perfect and couldn't possibly be improved.
Not so much.
Not so much, okay. So there will be a 7.0 in the works, and comments, suggestions, criticisms, whatever you want to give us in terms of feedback, we'd appreciate. Steve Bashaw works with Mr. Fortunato regularly in doing the case law update that you're going to hear this morning. He's on his own in Lisle. He's a former, I think it was McBride, Baker, and Coles you were at before, working on the dark side, working for the plaintiffs. And then he saw the light, and he came around, and now he's working on the other side of the fence and doing enormously good work, both in the foreclosure area. He's a go-to person for questions on how to resolve issues in these foreclosure cases, as anybody who's in the Association of Foreclosure Defense Attorneys knows. And we're very happy to have him here today with Mr. Fortunato. Erica Minchella is with the Erica Minchella Limited firm in Skokie. She's also involved with the Skokie Chamber of Commerce. She is an attorney who works in the areas of bankruptcy, helping people work out their credit issues and get control of their finances. She's very knowledgeable in this area. I've referred a lot of people to her. She's also currently chair of the Illinois State Bar Association Real Estate Law Section Council, as well as being an IRELA board member. So you basically don't have a life. You're just on the run all the time. I'm just going to turn it over to these folks, and thank you very much.
Thank you very much, Ralph. Every year we start out by putting the cases together and then talking about what theme they evoke in our mind, and Joe is our master of themes.
Well, we always have some difficulty finding a theme, but this year I decided that, and then told Steve, that the theme ought to be desperate times call for desperate measures from desperate real estate attorneys. And there are a lot of them out there. And that was a kind of a common thread we found, because people were desperate for causes of action, people were desperate for defenses. And so we get some interesting decisions as a result, because no one's safe when the appellate courts are in session. People say that about the legislature, but I tend to think more along the lines of the courts of review. And therefore, I think we're going to have something that initially didn't, I thought, well, we just have kind of a potpourri, or as they say in Quincy, potpourri.
Potpourri, right.
But we're going to have an interesting presentation for you. And of course, we always dedicate it to Harold Levine, who, in his memory. Steve, remind everybody who hasn't heard this before.
Right, you probably have all heard. Harold passed away a number of years ago, but prior to that time, he was very, very active in real estate, and especially real estate continuing education. I remember having lunch with him once, and he was bemoaning the fact that that morning his wife Barbara had gone to the nail technician, who was required to have more continuing education than he was. and he'd be pleased and proud to see that we're here. He would discount the fact that we're being drawn by breakfast, right? But Harold was an inspiration to us all, and we always remember him when we do our case law update.
And thank you, Erica, for being part of this presentation.
Thanks for
Really appreciate
inviting me. It was last minute. I'm not going to have an awful lot to say, but, you know, I'll pipe up when you guys,
But you've got a good viewpoint.
I do.
Right. After
Okay.
a while, we sometimes wonder if everybody doesn't get tired of the viewpoint. Unfortunately, Joe and I share a lot of the same gene pool. We're old white guys, and we need, you know, a little diversity up here.
And
right?
I'm pleased to provide that.
There we go.
Speaking of diversity, we'd like to talk about something besides mortgage foreclosure cases as
Yes.
well.
Boy, every year we get that. I don't know. I think it has something to do with me, and because that's what I like, right? But we get our comments are great materials, too much foreclosure. Great materials, too much foreclosure. Great viewpoint, too many foreclosure cases.
We don't own the chairs here, so if anybody wants to step up and
Yeah.
take over, feel free at any time. It doesn't take much, as you can tell from me being here. It doesn't take intellect or anything of that nature. It just takes a willingness to get in front of a microphone and fall on your face on occasion. But having said that, I thought I'd like to start by giving you some good news. And the good news is in the first case. The first case is what looks like it might be bad news because it's an attorney malpractice case, but it is a culmination of the thread in attorney malpractice cases that discuss the statute of limitations and the statute of repose. And in the real estate setting here, statute of limitations is typically 2 years from the date of the injury and 6 years from the date of the event I'm sorry, the 2 years from the date that the injury was known, or should have been known, and 6 years from the actual event that caused the injury. The Terra case involves a commercial construction of a building on Michigan Avenue. There was a term sheet that was entered into in 2005, and it discussed the pricing elements, and price wasn't exactly definite because it would depend upon the total square footage for the first couple of floors, being the retail space available for Terra, the owner. The builder was going to get the residential properties up above. And the agreement said there'd be adjustments depending upon the total completed retail space. Initially, they thought about 8,041 square feet for the first floor and plus over 10,000 for the second floor. And they were talking about what constituted the square footage. The term sheet specified that the calculations would exclude common area parcels, common lobby, residential parking, loading docks, elevators, and whatnot. When they got to the contract 2 years later, they tried to put that language in. When they did a First Amendment, I'm sorry, the First Amendment actually took place probably in 2007. The First Amendment to the contract didn't have that exclusionary language that would have benefited Terra, the owner, and instead they adopted something called the BOMA 96 standards, the standards measures for measuring floor area in office buildings, published by the American National Standards Institute, ANSI, issued by and published by BOMA, the Building Owners and Managers Association. Big difference there because the BOMA standards would not have excluded the common area parcels. So a large difference. Instead of Terra getting a credit at closing of $2.6 million, they had to pay $3.8 million. So they were not happy, of course, and brought suit against their attorneys, DLA Piper. But this all took place over a period of time, naturally. These things don't happen very quickly. They didn't get to this until well after the 6-year period from the time period when the contract amendment took place in 2007. And there's some evidence that Terra mentioned to their attorneys a couple times, hey, guys, you didn't include the exclusionary language. Oh, don't worry. So they went to arbitration in 2010. Terra lost. They went to arbitration in 2013. Terra lost again and said, enough is enough. We're filing suit. But by that time, it was 3 months after the 6-year period had run on the statute of repose. And the court said, well, you're too late. A statute of repose differs from a statute of limitations because it extinguishes the action after a defined period of time, regardless of when the action accrued, and forget anything about a tolling of the period for the discovery rule. So it is intended, the statute proposed is intended to terminate the legislation, excuse me, the litigation or any liability arising thereof after that period of time. Now, what about prior cases that talked about a difference between malpractice in a transactional setting and malpractice in a litigation setting? This case tells you there is no longer any difference. If you thought there was one because of some language in a prior case, we talked several years ago about Snyder versus Heidelberger, and the unfortunate language in that case where the court said, well, when the attorney drafted a deed for Mr. Snyder and his new wife, that was the last overt act that took place, and we don't look at the time period when Mrs. Snyder discovered that Mr. Snyder had hoodwinked her, and the title was in a trust all along, and he threw his lawyer under the bus and all that stuff. And that's what happens, people. Be careful. Lawyers, the clients will do that to you, as you know. That language really doesn't operate to terminate or to trigger the statutory imposed running period. It was just because it was the last event that took place. It just defined the fact that, well, there was nothing else that happened after that. So we can clearly point to that point. It's when the act occurred, when Heidelberger drafted the deed, and in this case, when DLA Piper forgot to put in the exclusionary language. That's the triggering point. 6 years after that, no cause of action. They could have brought suit earlier. They were 3 months late. And the court said there is no liability, and the lawyers can all breathe a sigh of relief. We don't have to worry about a continuing obligation to correct your errors either.
Right.
Thank God for that. So that's the good news I have for you in the area of attorney malpractice.
Well, that's what I found so interesting in this case, is that it was pointed out in the decision that the argument was made that at any time prior to the closing during this 8-year period, D.L. Piper could have corrected their error by reverting to the description of the common elements. And I don't know if you tripped over this, Joe, but I did. When you think about the common areas, elements that Tara wanted, they wanted the whole parking lot. This is a Michigan Avenue development. You know how many square feet of parking they must have had? It must have been huge, but that didn't seem to make any difference, right?
Well,
Even though they could have changed and corrected their error throughout this period, the actual occurrence was when they missed it the first time in the First Amendment.
right, because they had
That's
it in the
crazy.
term sheet. They could have been consistent and could have protected their client all along.
Right. Last year, we looked at the case of Lament versus Levine. That's where Levine was representing the client for a period of 17 years of litigation. I've got some old foreclosure cases, but I don't have any 17 years. And during that time, right, he had advanced these not so good defenses, right? And the court said, well, yeah, but he made the mistake back when he filed the answer 17 years ago, and so there was no liability.
It's amazing that you can pursue a groundless theory of defense for 17 years, but
Right.
so there's got to be some benefit there.
And then there's the next case, the condominium case, Strobe versus and Gatto versus West Bradley, is interesting because I think it's very timely, Joe.
Well, sure.
We're seeing a lot of associations. I'm seeing cases in which people bought condominiums in Chicago, paid $250,000 for them, and now they're finding out that their appraised value is $40,000.
Right.
And of course, they're saying, what can we do? What can we do? They have these meetings with the board and they say, well, we got to get rid of the renters, right? It's the leased units that are depreciating the value. So let's put in a regulation, right, that says you can't lease more than 30% of the units.
Well,
that's what happened here.
Yeah,
What was the
a
court?
desperate board tried to
Desperate?
tried to get around the limitation in the declaration. The declaration didn't come right out and say you can lease your unit. What it did say was no unit shall be
Yes.
leased or subleased for hotel or transient purposes. Thank God for that. I mean,
Yeah.
no Airbnb there. Or for terms less than 6 months. So even though there's no express provision allowing leasing, but the limitations there had to have some effect. So they're implicit that those leases, that there could be the rental of units. And there were no regulations in the declaration that said, what other limitations there would be, nor was there any power granted to the board in the declaration to regulate the leasing of units. That was significant. So when the board tried to adopt a rule saying no more than 30% of the units may be leased at any particular time, those unit owners who were affected by that brought brought declaratory judgment, a declaration that the declaration controlled, saying, you have to amend the declaration, and you need 75% of the unit owners to vote on that to amend the declaration to have any kind of limitation on the right to lease units other than those limitations already in place, because there was no argument that any of the tenants didn't agree to follow the provisions of the declaration and the bylaws, and there was no allegations or evidence of any transit usage. So therefore, the court said, well, yes, there are two different types of regulations that are permitted in use restrictions and condominiums restrictions that are contained in the declaration, and those have presumptive validity.
Right.
And those imposed by the association through its board of managers that don't enjoy the same presumption. And therefore, in this particular case, there had to have been an amendment to the declaration in order to pass this type of rule. The fact that the board got together and tried to do this was ineffective, invalid, and therefore not binding on the unit owners.
And that was good because, Joe, I think a transactional attorney reading this declaration, which we all do every time we represent, right, a unit
Absolutely.
owner, a buyer of a condominium, we all read the declaration word for word, you know, would have been perhaps in a bit of a quandary, because here the declaration, the court says, contemplates that owners have the right to lease their units, because it doesn't say that they don't. And that was exactly why they said we were going to impose the second type of restriction, right, inappropriately. You can't do it through your board of managers. Because the declaration is spoken on the matter of leasing, any augmentation or diminution of the owner's right to lease their unit must be accomplished through an amendment to the declaration, not a rule promulgated by the board. And I see more and more, I don't know, out west, gun-toting boards these days trying to deal with these huge diminution of value, and this is going to keep them in line, I think, a little bit.
I think it's going to be really important for transactional attorneys who wind up with clients who are finding that they can't rent their units because all of a sudden the rules changed, and they don't live in the property. They never had any intention of living in the property, and all of a sudden they can't rent it either.
Right.
And now having some guidance as to what they'll be able to do in the event that the board does start toting.
Yeah. This case is a
gonna
sign
be
of the
real
times,
important.
right, Erica?
Absolutely, I think it's
You're
going to be
gonna get
really
this
important.
question on the phone.
You know what? I'm sure that I have at least 3 cases that I should have looked closer at the declarations to see if there
Right.
was a good lawsuit
Right.
for those clients, because they wound up having to sell their units at short sales because there was no other alternative for them.
Right. The next case is a rehash and an update of last year's case about the implied warranty of habitability in new construction, the Fatima versus BIM case last year. The court said, right, that the warranty can be waived by a first buyer who then sells to a second buyer. Even if they don't know about the waiver, it's apparently still appropriate.
Well, in FATA, somebody bought a new house, and as always happens, the builder said, we're going to waive your implied warranty of habitability, and you're going to get an express limited warranty, and the buyer said fine, and then sold 3 or 4 years later, sold the property in as-is condition, even met with the builder, and the builder said, you want me to look at those stairs in the back, the patio, it looks a little shaky, and she says, don't worry, I'm selling as is. Naturally, the buyer bought. 3 or 4 months later, the patio started to collapse, and didn't bring suit against the prior owner, brought suit against the builder under the implied warranty of habitability, using the argument that the property ought to be fit for its intended usage, and there's an implied covenant that it is going to be built in a good and workmanlike manner, et cetera, et cetera. The appellate court bought that argument and said there could be liability on the part of the builder, depending upon how remote the construction was. It didn't say specifically that there was going to be liability. It was on a motion, but said there was a cause of action available to the buyer because the buyer didn't know about the waiver of the express warranty on the part of the first purchaser. A lot of people were worried about that. The Supreme Court took care of everybody by saying, no, just because the first buyer had sold the property, and if the first buyer waives, there is no implied warranty of habitability because they focus on the builder's expectations here. The
Yeah.
builder, they said, ought to be limited in time as far as what the builder's responsibilities are going to be after a fair bargained for limitation of the warranty. And that's where I take issue with the courts, because I don't consider these to be fair and bargained for. I think they're contracts of adhesion. I'd like to see a show of hands, how many people have represented buyers in new construction who didn't have to waive the implied warranty of habitability and accept the express limited warranty on the part of the builder. And I dare say that the limitations in the express limited warranty not only limit in time to 1 year typically, or never more than a year. I know you pay $20 million for a house, you don't get a limited warranty for more than a year. Also, I think there's express limitations that would be more limited than the law would otherwise imply under the implied warranty of habitability. So I take issue with the court's analysis that, well, you kind of have to do this. I think that was the result of what the court said. But what I'd like to do is let Steve talk about the Supreme Court opinion very briefly, and I just want to quote some language from the appellate court.
Yeah, go ahead.
As far as the Supreme Court is concerned, they said, well, I know I talked about how that the builder ought not to have be bound because of as the builder's expectations. And the defendant so-called paid the price to obtain the waiver from the implied warranty on the part of Lubeck. Well, I don't think that's the case either. Yeah. But the appellate court cited Peterson versus Hubschman and Rodarowitz cases and said the following about those things. The implied warranty of habitability provides that a house should be reasonably fit for its use. If the construction is defective, repair costs should be borne by the responsible builder vendor who created the latent defect. It applies not only to builder vendors but to subcontractors and developers, so forget the privity argument there.
Right.
It extends to subsequent purchasers. A subsequent purchaser is like the initial purchaser in that neither one is knowledgeable in construction practice and must rely on the expertise of the person who built the home for a substantial degree. The compelling public policies underlying the implied warranty should not be frustrated because of the short intervening ownership of the first purchaser. The warranty of habitability exists independently. Privity of contract is not required. The subsequent purchaser didn't know the home builder, as did the original purchaser. That fact doesn't negate the reality of the holding out of the builder's expertise of reliance. And finally, any reasoning which would arbitrarily impose a first buyer as an obstruction to someone equally as deserving of the recovery is incomprehensible, except to the Supreme Court of the state of Illinois.
Who said it certainly is comprehensible.
So there we have it. The Supreme Court has spoken. I'll shut up now and won't talk about it anymore.
I think the last thing that should be said was that your theme about desperate lawyers, right? Here's a lawyer who's looking for a cause of action, can't sue the builder, right? Because there's no privity on behalf of the second buyer. Can't sue under the warranty or make a claim under the warranty because the year is gone. So, right, what are they trying to do?
Can't sue the seller because it's as is.
Right.
Right.
It's already gone.
So as I
was an
said in my
as-is sale.
comments, there goes the implied warranty of habitability. You may as well relegate it to the dustbin of history.
There you go. The next case
Happy
is
note.
Second National Bank versus Jaffrey. It's a foreclosure case, but it's one that you might start seeing in your practice as we continue to roll along, right? The brief history of mortgage foreclosures in the United States, especially in Illinois. We're starting to see more and more cases that have resolved, gone through foreclosure, and now the property is being resold. In this particular case, what happened was there was a foreclosure. It was in DuPage County. The bank purchased the property for $900,000. The judge in the trial court entered a deficiency judgment for $577,000. Deed was issued to the bank, and then the bank sold the property 4 months later for $1,320,000. $420,000 more, right, than the property sold for at the foreclosure price. Not satisfied with getting a little extra money at the table, they decided to go back to the courtroom, and they sued the guarantors, the Jaffreys, under their guarantee for the loss, the amount of the deficiency, $577,000. The Jaffreys came back in and said, well, wait a minute, you made $420,000, we should get a set-off. Makes sense to me, right? Makes sense to you. Didn't make sense to the second district. The second district, much more philosophical than transactional, said where the mortgagee resells the property to a third party For an amount that exceeded the price paid at the judicial sale, the mortgagor is not entitled to a set-off in the mortgagee's later enforcement proceedings to recover deficiency judgment. Why? Because the foreclosure terminates the mortgagor-mortgagee relationship, which is the basis for the set-off. If you don't have a relationship, how can you get a set-off? If the mortgagor fears the mortgagee will obtain a windfall in purchasing the property at a judicial sale, the mortgagor may attempt to sell the property himself before the foreclosure. So it's an interesting situation. I'm concerned about this case, Joe, because I think it feeds and it supports what I see as an ever-growing sense of greed in the financial industry. I
And-
really see it that way. I know it's a little biased.
We'll sell the property for as low as possible, and we'll go after the
Yeah.
homeowners, and then we're going to go and also sell the property
Right.
for as high a dollar as we can get. And
Yeah.
and you're right, the level, the greed that is involved in that mentality is really distressing.
And Justice Shostak saw that.
Yes, I think she
Yeah,
was,
she dissented.
back down here on earth with the rest of us,
Right.
agreed that, that there should be no double recovery, which is what this allows. There should be no opportunity on the part, or if there is an opportunity on the part of the plaintiff to manipulate the sheriff's sale, they shouldn't benefit from it, because they do, because they're almost always the only bidder. They can control the amount of the initial bid, control the amount of the size of the deficiency if they want to. And so the court said, hey, we're an equity court.
Right.
She says we should not allow two recoveries of this nature, which is frankly all this is.
Right.
You have the right to proceed against the property and to secure money judgment for deficiency, but you only get one satisfaction.
Right. So the combination of the more than one satisfaction, approaching double satisfaction, together with the bank's ability to manipulate the sheriff's sale, that's what's really interesting.
And the duty to mitigate your damages,
Right.
which they just completely blew off. So I think you could make a really strong argument next time you have to by adopting the reasoning in Justice Shostak's dissent here.
Right.
But one of the other issues that was raised in here too was that, I lost the thought.
That's all right. What's your question?
The question.
Yeah, I was confused with your statement that the lender
Repeat the
has
question.
the right to manipulate this.
That's what the
Right.
court characterized it as.
But do you think they have the right? to-
Absolutely. I see it
Absolutely.
every day.
And how is that done?
They go in and they lowball bid. They get an appraisal, right? They get 3 appraisals. They take the lowest. They take and take 25% off of that and then bid. I had a foreclosure sale that's under advisement right now. Property in Harvey, right? Not so great.
Okay.
$177,000 balance. The lender bid $18,200. The lead in the property is worth $18,200.
Yeah,
You know,
yeah.
I see manipulation every day.
But isn't the purpose of a public sale to sell to the highest bidder?
Well, of course it is. Right. Well, there's another fiction, right?
Well, yeah, but
Yeah.
I presume there's still buyers out there, professional buyers,
Mm-hmm.
commercial buyers, that would buy it more for $18,000 if they thought they could make a buck.
Well, we could argue this forever. We've
Yeah.
got 15 cases we have to go.
Yeah, if you sit in the sheriff's sales, you will see that maybe 10 to 20% of the sales actually have bidders in there
Right.
going after them. And the point I wanted to make is that one of the other things that the court indicated as to another reason why this was an appropriate decision is that you could come in and contest the order approving sale.
Right.
The ability to contest an order approving sale is like so minuscule that it virtually doesn't happen. I think I have one case pending right now it's working in.
And an objection to a confirmation of sale based on price alone is not sufficient. You have to have
Right.
something more. That's right, the black letter law. So the next case is a Mortgage Rescue Fraud Act case that's not about mortgage rescue. ALSJ versus Kurtz was a situation where ALSJ brought an action to foreclose a mortgage, which the court said was facially outrageous. Talk about manipulation, right? It was a 1-year balloon mortgage that provided for 36% interest that was made to Mrs. Kurtz when she inherited her mother's home and discovered there was about $8,000 in delinquent taxes. It would later cost $28,000 to redeem. When they filed the foreclosure action because she didn't pay off the mortgage that they used to help her redeem, right, she filed an affirmative defense taking the position that this was a violation of the Mortgage Rescue Fraud Act. I like that because obviously the attorney for the buyer, or for Mrs. Kurtz, was thinking a little outside of the box. Just because it said mortgage in the title of the act doesn't mean it only applies to mortgage. It also applies to loans that are made to help people who are facing a tax deed, who haven't paid their taxes. So there are a lot of facts in this case. One was whether or not ALSJ was a, quote, distressed property consultant as defined in the act. They were. You can read the facts. It might help you. Second was whether Kurz was a consumer and the loan was not residential. Here's an important fact. At every one of the closings where ALSJ rescues people, they make them sign a statement that says this is a commercial loan.
Stephen, in fairness, I'm familiar with ALSJ, and they really are hard money lenders for commercial commercial developers. They will lend to people who are doing flips. This is I really think that this particular loan was outside of their wheelhouse, and that the documentation that they had them sign was the same documentation that they had investors who were using them as their hard money lender to get through their transaction.
Right.
So the problem is that they use the same documents for a residential property.
The quotable language out of this one, I think, in this case, Erica, is, quote, having a homeowner sign a paper saying it's a commercial loan doesn't make it a commercial loan, right?
Correct.
They came back and said this is clearly not a commercial loan.
Well, but she didn't live in the property, so they were trying to argue that this was a commercial loan because, and as the court decided, the fact that she didn't live in the property didn't make it a residential, a non-residential
right.
situation.
So that became an issue of fact. There are huge numbers of issues of fact in this case, but if you come across a situation, this is the one to read.
Why did she keep the $66,000, Steve?
Well, the court came back and said, it's true. Well, they didn't say it's true. They said the remedy of rescinding the loan, because that's what the trial court did. They said we're going to rescind this loan because it violated the act, was upheld despite ALSJ's argument that it would result in a windfall. For Kurz, right? Because she didn't have to pay the $66,000 back, and she got her payment of her taxes
And her attorney's fees.
and her attorney's fees. Right? What's wrong with that?
What's wrong with that? Right.
The
Well-
court said, quote, rescission is an equitable remedy, and we will not disturb the trial court's decision to rescind an agreement unless it abused its discretion. Essentially, what they're saying is, with all respect, right, to your client, Erica, is that they didn't like them, and so they said, we're not gonna replace our disdain for the
In this situation,
fraud.
they didn't do it right. Their normal business practice is not to deal with homeowners. They deal with investors. But this was a woman who was desperate, found somebody who was a mortgage broker who went, I know who to put you in touch with, and I think that's what happened with this one.
and they made quite a deal out of the fact that third place removed referral agent got $5,700, but who knows. The next case is about another mortgage foreclosure case, but it's one that an issue you're going to recognize. In U.S. Bank versus Junior, the question was, what do we do about endorsements in blank on notes? In other words, where you have a note that's endorsed in blank. You may all recall a few years back, the big issue was, where's the note? Where's the note, right? And we have slowly but surely, step by step, without any back steps, right, gotten to the point where you don't need the note. The majority opinion in this case rejects the reasoning, that you have to exhibit evidence of the note. Doesn't have to be the note. Doesn't have to be exhibited in court. Justice Gordon dissents. And there's another decision in Wells Fargo Bank versus Mundy that came out this year, right, that adds to this mounting precedent. And it's important, I think, to notice the Junior case. Boy, we just get so many bad decisions made by pro se defendants or attorneys that really don't get it. And this is another one of those cases. The court just came back and said, you really, don't have to have the note. They went through First Federal Savings and Loan versus Chicago Title. And, of course, the Korzen, Korzen case, which gets cited a lot. And in that case, Justice DeLorte said For over 25 years, the foreclosure law has been interpreted as not requiring plaintiff's production of the original note, nor any specific documentation demonstrating it owns the note or the right to foreclose the mortgage. I raise that all the time. And, all the time I'm getting denied, right, on motions to dismiss. What I have started to do, Eric, I don't know if you started this, but I've started doing notice to produce at trial, right? Just produce the original note at trial. And we'll see if the judge thinks that a motion for the entry of summary judgment is a trial or not, but I've got about 4 or 5 of those outstanding. If your client comes in and says, well, I've been reading the internet, what about where's the note? You can show them this decision. Justice Gordon dissents, relying on the fact that the record didn't indicate that there was a Supreme Court Rule 113 affidavit. Thus, the defendants were correct. They failed to receive due process to which they were entitled. And he said no judgment of foreclosure should be entered without compliance to subparagraph C of Rule 113. And that subparagraph mandates the plaintiff submit an affidavit attaching not just the payment history, but the records, and that should include the original note. But that's a dissenting opinion. And there's just an interesting thing, and it's pointed out in the materials. Rule 113C3 says, quote, additional evidence. The affidavit shall contain any additional evidence as may be necessary in connection with the party's right to enforce the instrument of indebtedness. So maybe the attack point that was missed was that, and Justice Gordon picked it up, was that it didn't say in that affidavit that, here's the note and it's endorsed in blank and we're the holder and we have possession. So it's interesting. What did you think about that case?
I always like Justice Gordon's take on the cases because he generally tends to look at it through the lens of what the Supreme Court did in the mortgage foreclosure.
When they updated through the committee. Sure, he looks at what evils were they trying to rid us of in the midst of the recession.
Yeah,
right?
And he's been pretty consistent in his decisions.
I think he is too. The next case is Wells Fargo versus Mundy. We mentioned it in the junior decision. Basically, it takes it one step forward. There are a number of attorneys, some of the very high volume firms, who, when it comes to capacity, allege that their client is the, quote, mortgagee under Section 1208. Well, Section 1208 is a little interesting. It's in the short form complaint, of course, and it provides for 4 categories of capacity: as the legal holder of the indebtedness, as a pledgee, as an agent, or as a trustee, right? And a number of cases have led to the point of saying that pleading in the alternative by referencing the section is appropriate. Advic, a couple of years ago, we highlighted that case. Maldonado was in our updates. Rosestone Investments versus Gardner, and of course the Corzine case. But it basically seems that these cases are culminating in this trend of the appellate court's thought in a mortgage foreclosure proceeding that capacity is a red herring. Don't tell that to any borrower who comes in and you say to him, who's your lender? And they say, I don't know, but it keeps changing, right? Who's the lender? They don't know. So that was an interesting case, but it follows directly from the junior case. Then we have, of course, another one, U.S. Bank versus Johnson, foreclosure case, failure to name the mortgagee, res judicata, and a bona fide purchaser. In this case, there was a 2009 foreclosure action that it named BNC Mortgage, BNC, now owned, whatever that means, by Chase Home Mortgage. And then they sent out, the service of summons, and the service was on the registered agent of Chase Home Mortgage Finance, the sick owner, whatever that means. Default judgment was entered, which of course extinguished the interests of BNC, now owned by Chase, and it was foreclosed. Thereafter, a consent judgment was entered, vesting the title, in the property in the plaintiff, free and clear of all claims in the interests of the subordinate lien holders, like this second lender. But of course, did they get served with a summons or didn't they? Were they properly made a party? And in the trial court, hearings revealed that BNC closed its doors in 2007, and the mortgage to U.S. Bank was recorded in 2009. I guess 2 years don't mean too much, or 3. and that this was the reason that VCB joined Chase Home by virtue of the mortgagee in its proceedings. The trial court applied res judicata and held that the service in the prior case conferred jurisdiction in the court, which extinguished the Chase Home Finance interest in the proceedings, and the consent judgment was a bar to the enforcement of its mortgage lien. I use consent judgments more and more these days in defense simply to avoid deficiency judgments.
So do I.
Yeah, and you're gonna see this coming up again and again. The
But
second,
this one had the assignment in it, though. That was
it
the
did.
problem.
Yeah, well, but this is like the Deutsche Bank versus Gilbert case. The assignment's out of the chain, right? Or at least if you put in the mortality of the company that purportedly did the assigning. But I guess it was missed at the trial court. What do you think of that?
Well, whoever did plaintiff's attorneys didn't either do minutes of foreclosure or the title company messed up. But as we know from some of the comments on some of the later cases, title company's free to mess up if they want to, and you can't rely on that. So
Right.
yeah, a plaintiff can't rely on the fact that they ordered minutes and didn't see the assignment to U.S. Bank, and they should have done an independent search. Anymore, you might want to just go on the internet and check your county recorder and see what recorded documents there are, and you might be able to find that assignment and then join that party. I think that was a fatal flaw here. U.S. Bank assignment was in place prior to the filing of the lawsuit.
But there's so many servicing transfers. You know what I mean? You'd have to update your search, Joe, every 30 days, I think.
And the assignment isn't always recorded, so
That's
there's
right.
really no
It's
way
MERS.
for you to have public, any kind of public knowledge of the fact of who owns the mortgage.
It's easy for us to be critical, right, of the appellate court because we have perfect hindsight.
Of course.
They're just trying to come up with some good, firm rules. But here, the other thing to notice was that the summons designated et al. For the defendants on its face. That's defective, right? Even though there was the correct number of the trust as set forth in the body of the complaint, that doesn't confer jurisdiction. In this particular situation, the failure to name U.S. Bank or MERS was held by the court not to be a, quote, misnomer, that's a word I see more and more from plaintiffs' attorneys, right, but rather one of mistaken identity. The effects of mistaken identity is the court does not acquire personal jurisdiction. A misnomer is you got the guy, you just got the wrong name of the guy.
We got a question from someone who knows more about this than you do.
That's for sure. Hi, Mark.
Was there any mention in the opinion
Repeat the
why the U.S. Bank didn't just file a motion to vacate the prior judgment?
Repeat the question.
Was there anything in the decision that indicated it? You know what, Mark? No, there wasn't. But I'll be honest to tell you that you'd be able to read this and read between the lines. The truth of the matter is U.S. Bank was a trustee. U.S. Bank is a place in Kentucky. They service about 20 or 30%, from my opinion, of their loans. The rest of them, they're just acting as trustees. So that when they get a notice in, they just send it to where they're supposed to send it. I don't think that they really understood what was going on. This isn't like the Fankhauser case, some of these other cases. There's just such a high volume, right, that they just miss these things.
Jurisdiction is jurisdiction. I've been successful
It-
setting aside judgment years later because it's effective.
You're exactly right, 100% right. The first thing every defense attorney should look at, the last thing every plaintiff's lawyer should look at before they walk in for a judgment is jurisdiction, because that's the one fly in the ointment that you can't, disregard. Yeah, Joe?
I was going to say, I wanted you to repeat his comment. Jurisdiction is paramount here, and that's what controlled this situation. Judgment was void.
Right. And, of course, in this case, Smith was on due inquiry notice. The next case we have...
That's interesting, too, because he's on due inquiry notice of a recorded assignment that
Right.
that the plaintiff didn't even know about or didn't do anything about. So that's interesting, too.
The next two cases are
Oh,
about
yeah.
tenancy in the entirety.
Oh, yes.
And boy, we really have to go to school about this because it seems like there's a lot of confusion about tenancy by the entirety, and it's not that confusing.
I've been waiting to get an opportunity to talk about these two, the Perilli case and the CELAC case. It turns out the right way and the wrong way to do it. Here in Perilli, there was a mortgage, and I'll try to cut the facts down time-wise because we don't have that much time. Mrs. Purley signed the promissory note on one of the refinances. There were several. And she signed the mortgage. Mr. Purley signed a waiver of homestead. He was not identified in the mortgage instrument as a borrower. The borrower is defined in the standard Fannie Mae mortgage, paragraph 13. If everybody wants me to read the language, I'll read it. I've got it here. So if you're not listed as a borrower, and you don't sign the mortgage, and you're the spouse of the person who is signing the mortgage, and you hold title and tenants by the entirety, that mortgage is a nullity. It's no good. Because the Joint Tenancy Act says if you hold title and tenants by the entirety, it takes signatures on no document should be effective unless signed by both tenants by the entirety, deed, mortgage, lease, whatever. So Mrs. Purley alone signed. The waiver of homestead was deemed to be worthless. It wasn't the same as a pledge of an interest. It wasn't a voluntary pledge of a property right, and therefore, the mortgage could not only was not effective, couldn't be foreclosed, it couldn't be reformed. There was an action for reformation brought again, and on these situations, plaintiffs try to reform the mortgage and say the non-borrower spouse should sign it. That was the intention of the parties. Well, that's a question of fact, and you can get into that. And I think that's one of the remaining issues in this case. Should there be an equitable lien? Was there unjust enrichment and so forth? Was there fraud on anybody's part? Well, those are very strict burdens on the part of the plaintiff. And remember, you've got a limitation period on some of these things. And of course, when you get past the standard 5-year statute of limitations period for some of these actions, then it's too late. And a lot of times these things aren't discovered in this setting for more than 5 years because they were made in 2004 when mortgages were flying around all over the place and nobody was really checking very carefully about what was going on. And then after the bottom fell out in 2008, and then people started defaulting on their loans, you get past some of this 5-year limitation period for some of these actions. I know there's a different limitation period on written instruments, but some of these correlative causes of actions failed under the statute of limitations.
And the court saw right through that because, Joe, your point is exactly right. What happened here is that Mr. Pirelli signed, but he didn't pledge. He signed for the purpose of waiving homestead. And I think if you took 100 closers, non-lawyer closers, and stood them in a line and said, okay, here's the facts. You give them these facts and you say, what do you do? And they would, 99 of them would say, you make them sign to waive homestead, right? Because that's what's drilled into them. So they really don't truly understand tenancy by the entirety.
Right, and then they don't understand that it's not a pledge. If you're an owner, you sign a mortgage, but then you can only have one sign the promissory note, and that's effective. Now, the CELAC case tried to argue, again, a little bit of a Hail Mary here, when both parties signed the mortgage, but only one party signed the promissory note. The person who signed the promissory note said, well, you know, that my pledge was not effective because there has to be an underlying debt by both of us in order to have foreclosure. The court did not buy that argument.
That's a standard concept that foreclosure or real estate lawyers generally have about mortgages. In order to support a mortgage, you have to have an underlying debt, right? So when the attorney saw this one come in the door and said, Eureka, there's no underlying debt, the appellate court basically came back and said, what? A mortgage is a consensual lien, right?
Right.
And they've created a consensual lien. You didn't have to have a debt. All you had to have was a consensual pledge of collateral, right, to overcome the limitation of the Tenancy by the Entirety Act. So it's...
And there was an underlying debt. It was signed by one of the tenants.
Right, and the court says, and there's, I can't sign the exact language, they say, all the time we see situations here. It's not uncommon for notes and corresponding mortgages securing them to be executed by different parties. That's what a guarantor is, right? We see that all the time.
I think that what they were trying to say is that there could be a hypothecation, but they just didn't use the language hypothecation.
Yeah, we
because
don't know that
we see
language.
That,
Yeah.
we
That's East
see
Coast
that in
language.
business, but we see that in business transactions all the time, where there's an additional piece of collateral that's given that has nothing to do with the loan itself. And in order to make sure that the mortgage can be foreclosed against that property, you have a hypothecation agreement. And I think that's what the court was trying to get to.
Right. So in
Okay.
summary, on tenancy by the entirety, right, a tenant need not execute the note underlying the mortgage, but must execute the mortgage in a manner that constitutes or reflects a pledge of collateral for the debt. That's what makes it enforceable. And you also, what you can take away is watch out, because the mortgage could be reformed. The mortgage could have a timely claim for equitable lien. A timely claim for unjust enrichment could be pursued, and conventional or equitable subrogation is pled, right? And fraud on behalf of the tenants by the entirety because they tried to defraud the lender. But that could be alleged as well. The truth of the matter is, I know the attorney that handled the Pirelli case, as well as the attorney that handled the CSLAC case. The attorney who handled Pirelli got lucky, Joe. He got lucky because he threw a fastball down the middle and they were looking for a changeup and never saw it coming.
Well, he should have been lucky because he's right. All right, we got 10 minutes left for five cases.
Okay, we'll go quickly through the next case, FRS versus American Community Bank. And the reason we're going to go quickly is because it'll take you 3 readings to understand it. It was a foreclosure case. But what's at issue here is not the real estate, right, but the recapture agreement that the developer had with the village of Huntley to recapture the costs of the development. For instance, there was intersections and I think some sanitary sewers and things like that. And the recapture agreement allowed the village to collect user fees from people outside of the subdivision and then pay it to the developer. And the question was whether or not, in the foreclosure case, the lender foreclosed the right of the developer to get those recaptures. Well, the answer was here, it wasn't. You can read a lot of facts about waivers and a consent judgment, but I think it really boils down to whether or not the recapture right is a real estate or a personal property issue. And they decided that it was a personal property issue.
Could you properly secure the personal property with another document?
Absolutely.
Okay.
Well, actually, what happened is there was some confusion about that because they did file a UCC statement, right? A financing statement, and they included the recapture. The problem is they later released it.
Right.
Right?
Okay.
So they were just trying to close the door after the cow was already out. Erica, what about the grace period notice? This is a Rule 23 decision. Chicago Patrolmen's Federal Credit Union versus Walker, but it's got some pretty decent reasoning in it.
You think? Okay.
Yeah, maybe.
We were really pleased when the Arriaga case came out because Justice Gordon basically said grace period notice is the last chance that the homeowner has to make sure that they know that there's a default and there's a way out. And what happened in Chicago Patrolmen's Federal Credit Union versus Walker is that the defendant claimed that no grace period notice had been given. He had maintained a file with all the documentation from the mortgage company. There was no grace period notice that he was able to find, and he provided an affidavit to that effect. The lender came back with, or servicer, no, in this instance, it would have been the lender, came back with an affidavit saying, yes, we did send a grace period notice. Here it is, undated, directed to somebody else. The address was correct, but the dear sir was to somebody else. And it went out, the same day that the notice of default went out. It must have, because that's what our records show would be the normal course of business for us. The fact that the grace period notice was undated really, by the attorney who told me last night, he thought he had a slam dunk on because there was no proof of when the grace period notice could have gone out because there was no date on it. Didn't seem to sway the court at all. They seemed to feel that the fact that the affidavit said, we sent it out and we know we did because that's how our normal business of transactions with regards to grace period notices would be done.
Right.
So.
And I don't know, when are we going to get to that point in our jurisprudence? I mean, essentially, the appellate courts are still believing that whatever the bank says must be right. They don't know. They haven't gone into a financial institution lately and been confronted with people who don't know very much.
At the a meeting of the Association of Foreclosure Defense Attorneys last night, we were talking about if you look at the appellate hearings, if you look at the online hearings, you will see virtually every justice asking the defense if the defendant had paid the mortgage, as if that has anything to do with the defenses they are raising for things like grace period notice or notice of default. Whether they're paying or not doesn't change the fact that there are other defenses that they're entitled to and that they're entitled to the same protection of the law as any other litigant.
Right. There's an editor's note at the end of this referencing you to Bayview Loan Servicing versus Sparza and Sarzek. That's a case that has to do with grace period notices. It doesn't have all of the good facts, I think, that the other case does, but what it is it's not a Rule 23. It started out as a Rule 23, and then they removed that order and made it a citable decision. But they affirmed that there was no obligation to send a grace period notice when the mortgagor has filed a bankruptcy. So make sure that you talk to your clients if they say, I never got a grace period notice. You know, even if they can say things like, you know, here is a photograph of my mailbox every day for a year before.
You have to look at the
Yeah.
date of the grace period notice in relationship to the bankruptcy, though. If the bankruptcy occurred after the grace period notice should have been sent, you may still have a valid
Right.
a defense. Janice?
Just as a note, as far as grace period notices are concerned, the statute expired July 1st.
Right.
It was, I'm pretty sure it was extended. I thought it was
Thank you.
extended.
I saw nothing that had that.
I'm not sure. We'll have to check that, but I'm not sure that's true. Okay,
thought it was extended.
what about confessions of judgments? I hate confession of judgments.
In less than 60 seconds, I'm going to cover this. Confession of judgment, we all hate them, or a lot of us hate them. They're not allowed, generally speaking, if you need extrinsic evidence to determine the amount to be confessed. Well, how could you confess judgment when an amount is undetermined? In a situation involving a principal amount that's fixed, but an interest rate that is dependent upon interest occurring at a publicly announced prime rate of interest published by a bank, you'd have to go outside the instrument to determine the amount, so the trial court said you cannot confess judgment on that amount. The appellate court said not so fast. It's true that confession doesn't extend to uncertain or unliquidated sums. Here they determined that the sum was determinable without going to a hearing. They did have evidence outside the record of the document attached to the complaint, and the court hung their hat on this. The court said when the plaintiff demonstrated that the amount is determinable by attaching documents, and no one's disputing their documents, that transparently show a simple calculation of the amount owed under the note. In that situation, the court said that was sufficiently determinable. You didn't have to go or the instrument or outside the record to determine the amount. Kind of an iffy calculation as far as I'm concerned, but the court said it was fine. And also they went to the UCC and determined that, you know, you can have an instrument that has a variable rate that makes it a negotiable instrument, and therefore you can confess judgment on it. That's the rule now.
All right.
We don't have a lot of time, but we got to talk about title insurance because this case
Must
has
be.
not gone away.
Yeah, there must be some self-interest in it because it takes us 7 pages
Oh,
to
gosh.
cover whether or not, right, you can get attorney's fees as an attorney agent, under what circumstances, and where you've compromised that.
Under Section 8 of RESPA, an attorney can get paid for services, core services rendered to a title insurance company or other services necessary and determined by the title company to be appropriate to issue a title insurance policy. The Chilton was a class action lawsuit in Colella, its companion case. Chilton was against Tycor, Colella against Chicago Title. The time period was 2000 to 2005. There was an allegation that the information provided to the attorneys was sufficient to constitute a title commitment, and when the attorneys signed it and signed information and sent it back, the attorney really wasn't doing any work, therefore shouldn't get paid under Section 8 of RESPA.
They were just signing, not doing core
Signing and not
title.
doing core title services,
Right.
not doing title exam. I have a personal interest in this. I testified for the defense. Mike Rooney led the charge for the plaintiffs. At trial, the court did, and there was a couple different iterations of this. At the time of appeal, the first appeal, the court said if the plaintiffs can show that what the attorneys were provided was what they called a pro forma commitment, in other words, was already predetermined title insurance commitment, then therefore the attorneys couldn't get paid. We were able to convince Judge Mikva at trial that the attorneys still had work to do, and the plaintiffs' attorneys, experts admitted that the attorneys did some work. They just argued they didn't do enough work. At the end of the day, the court realized that you can't really insure a mortgage that you haven't seen. That's why we all look at the mortgage at the time of the closing to make sure, for instance, in a tenancy by the entirety situation, it's signed by both borrowers, both spouses or parties to a civil union. We do title review all the way through. There was testimony that the attorneys did work all the way through. Therefore, as in Judge Mikva's opinion at the trial court, they didn't do a lot of work, but they did enough to get paid, and RESPA is not a price control statute under Quicken Loans versus Freeman. Now, to go back to this, there was a dissent, and the dissent was by Justice Paczynski, and she said, well, not so much, because she said these were all, and it wasn't it's not in the materials, but these were all predetermined title insurance commitments, and I don't care what you call them, the attorneys really didn't do any work. Now, she said you shouldn't have had evidence at the time of the trial to talk about what the attorneys did, because there was a foregone conclusion that they didn't do anything, which strikes me as odd, but I'll
That
let
was
you
the
comment.
prior remand. On the prior remand, the court said, sending it back, that, quote, if the plaintiffs are able to prove at trial Tycor's A examination, that's where they give you the commitment, and CIT's preliminary commitments, or what might be a commitment, are, quote, pro forma commitments, defendants cannot lawfully send their attorney agents pro forma commitments and pay them full compensation. In other words, she said, that's what we said when we sent it back, but the trial court let Joe talk, and Joe talked them out of it, right? So, it's an interesting thing. I think what's important here too, Joe, is that the evidence and the expert testimony established that attorney agents perform a number of tasks independent of representing their clients at closing that have to do with this attorney agent, and they list 7 of them. They order a title package. They identify liens and encumbrances. They clear the liens and encumbrances before the closing. They verify title in the seller and the ability to convey. They recommend the documentation process and to clear title liens. They attend the closing on behalf of clearing the title, or for the purpose of clearing the title liens, and they maintain records of the transaction.
And most
Basically,
importantly, they assume liability for what they did.
do,
And that was the
exactly.
determining factor in the trial court's mind. Justice Paczynski doesn't agree, doesn't think that there's any liability at all, and I disagree with that conclusion.
Right.
Because I think there is liability that attends to the action as a title insurance agent. So now, the reason why we're talking about all this is that a petition for leave to appeal
Appeal has occurred.
was granted, and we'll be talking about this again after the Supreme Court weighs in on it. Stay
Okay.
tuned.
Paczynski said, quote, these were plain and simple kickbacks for referrals, and no matter how you dress them up, they are still kickbacks, they are still wrong, and the class can demonstrate violations of both federal and Illinois law. So clearly, right, the battle over attorney agency fees isn't over
It's
yet.
not done. Finally,
the
we're
last case.
we're already late. Sorry, guys. Hatcham versus Chicago Title et al. was an action primarily against a seller. A buyer bought property in a residential historical district, and the seller didn't tell the buyer about it, and the buyer didn't check. The buyer bought it, found out that it was in a historical district, didn't see any plaques or anything like that, and said, well, wait a minute, I want to cancel this transaction, I want my money back. Court said, no, you took title subject to, the contract said you take title subject to
Covenants.
general real estate taxes, covenants, conditions, restrictions of record, building lines and easements, if any, provided they don't interfere with the current use. You got marketable title, that's what you got. This was a matter of record. The fact that you didn't check, the fact that the title company didn't mention it, is not of any consequence. Now, they brought action against the title company just said, well, first, you're not the insured because the insured was a trust, but second, you don't have a cause of action against us because we don't have to tell you.
Yeah.
I mean, and you could go back and read the United Community Bank case, which is one of my favorite cases, that says, and I'll just paraphrase, there's no duty on the part of the title insurer to parties to a transaction where title insurance is purchased to discover a judgment lien or describe risks. Even in its search, Commonwealth, in this case, discovered the judgment lien, but consciously and intentionally omitted the lien from acceptance of coverage. That would be Commonwealth's business and no one else's. Yeah, right. So
How would I find that as a buyer's transactional attorney? I'd read my title.
right.
I'd look for an exception in Schedule B that says, that this is a landmark designated property or in a landmark area. And if I was paying attention, right, I'd ask to see that and then try to, read that landmark designation
And
ordinance.
if you read your commitment and there was nothing on schedule to be about the landmark.
What am I to look for?
There's nothing to look for. But title companies don't sell information.
I can tell you that in Evanston, it is all on their website.
There you go.
So you may want to check the village or the city that you're working with and see whether there's anything online
So
that indicates it.
6 months from now, I'm gonna be sitting at my desk, one of these is gonna come across and say, did she say Evanston or Elk Grove Village? It began with an E, right? But it's getting
Just
crazier
call me,
and
Steve,
crazier.
just
There's
call me.
no tip-off. Yeah.
Right.
Have a
Sorry.
question
sorry.
here?
Yeah, question. Fritz.
The landmark designation, was that a part of an ordinance or was it a state statute or?
It was an ordinance,
ordinance.
and the ordinance required the Landmark Commission to post a plaque, and of course, they failed to do it.
Well, but I think title companies do not do anything with ordinance.
Right.
I think that
Right.
Right.
Just this landmark thing.
Right.
There's a local ordinance.
Yeah.
You can't rent the upstairs of a garage or
Right.
something like that. They don't cover any of that.
Yeah,
Right.
that's
You
what-
can't
that's how it
paint them with a
wouldn't fit.
color that didn't exist in 1890 or
The
something.
point is, yeah, and I'm not
you
trying to
know.
castigate title companies. It's not their job to do this.
But
So,
the
but
question
it's-
is, whose job
whose job is
gonna
it?
tip us off?
Well, I don't know the answer to that,
Yeah.
but be careful out there.
Another question, maybe?
Yes.
Or an answer?
Sure, something, no, I don't have to answer a good question, something even more common. Something even more common, municipal zoning where property doesn't conform.
All right.
It's in the village ordinance, but does the attorney have to look at residential transactions?
Hmm?
Zoning the house?
Sure. Sure.
Well, and then there's the question about whether an attorney commits malpractice, for instance, in a commercial setting where the title company does mention, the zoning classification and the possibility that the property doesn't conform to the zoning classification. What's your duty there? Another question I'm not going to answer. I'm just going to raise the question. There are all kinds of questions out there. That's our job, is to raise the questions. You're all lawyers. You're going to have to find out the
Find the
answer
answers, right.
yourselves. Yes.
But
And-
hopefully you'll find them out in a way that won't end up in next year's case. law,
Exactly.
Right?
Well, if there's any consolation, this year's attorney malpractice case was good news for the
Yes,
attorneys. So,
right. Can't wait
again,
till
a lot
next
of desperate lawyers and desperate times
Right.
and desperate measures, and that's the good news we have for you today, and we're sorry we ran late. Thank you for your attention.